Hello ladies and gentlemen, welcome back to my channel. This video is made on the request of one of the comments that I should make a video on the sources of law, and this is in respect to sources of law in Uganda. I know that some principles are applicable in other countries, but I'm mainly basing this video on the sources of law for Uganda, and this video is meant for business law year 1 students who don't understand much about the law or what the law is. So the first source of law that we talk about is the Constitution. And by Constitution, we're looking at the supreme law of the land. In all countries, really, the Constitution is the most supreme law of the land. And principally, it lays out the rights and responsibility of the citizens, as well as their duties. So it is a law that all other laws emanate from the Constitution. In Uganda, at the moment, we have the 1995 Constitution, which is still the Constitution in place. And any other law that is deemed to be contradictory to the Constitution is deemed to be null and void. So the Constitution is a very first source of law, and it's a source of law because all other laws derive their validity from this Constitution. The second source of law is what we call legislation, and legislation really refers to written laws that are created by the national law-making bodies. So the first type of legislation we'll look at is the acts of parliament, the laws that are made by your parliamentarians or the MPs that you choose. So these laws are called acts, and they are in books or different law books, and these acts of parliament are the supreme source of legislation. In terms of ranks of the different types of legislations we're going to look at, the acts of the parliament are the supreme ones. They are the parent laws. They are the most top of the legislation or the types of legislation that exist. So acts of parliament are a source of law because they are made by your lawmaking bodies, the MPs, and then they provide the different laws that are in existence. So many of these acts start as bills. The acts of parliament usually start as bills. And what is a bill? When we talk about a bill, we are saying a draft proposed act of parliament that is going to be tabled before parliament for consideration. And this proposal can be proposed by either cabinet ministers or a government department. Let's assume there is an issue of noise in Uganda, and you want to move, the people to change laws on the noise. You talk to the ministry responsible. If you're able to persuade them, they come up with a proposed bill that can be tabled or that is tabled before cabinet. So they table it before cabinet to get cabinet approval, to get goodwill from cabinet, and the cabinet minister then presents it to parliament as a bill. So the bill goes through several sessions in parliament, and the first session is what we know, or the first procedure, we call it the first reading, where it is formally introduced before parliament that there's this noise bill we are doing, how different is it from their existing laws on the noise, and then that the bill is committed to a relevant sessional committee. A committee is created to be able to address this bill or to handle issues concerning this bill. So the minister really introduces the bill, and anyone else who has anything to say about the bill can say it at this point in the first reading. So in the second reading, which is the second stage, so to speak, is now the sessional committee goes, of course, and addresses the bill, looks at researches, talks to people, does all its work, and then it comes and submits its report to Parliament in the second reading. So Parliament considers the bill, and they debate the principles and policies in the bill, not the details, not the nitty-gritty, just the concept, the principles, what are they trying to say, what is it all about. That is done in the second reading. So in the third stage, or the committee of the whole house stage, Parliament deals with the bill provisions. They look at it clause by clause. What does this clause mean? Is it good? Is it bad? What should we add? What should we remove? And then in the third reading of the bill, this time the bill is not debated. It is already, most of the work has been done and addressed, and it's brought for passing before Parliament, and it's passed as a motion that the bill is now read the third time and it's going to pass. So at the third time, they are not debating anymore. The debating process has been finished. Sometimes you hear, oh, this bill is in the third reading, then you know what stage at which it is. Or they'll tell you, oh, the bill is before the president for presidential assent. Then you know that it has finished all the other parliamentary processes. It has now been sent to the president for consent. And this happens in all jurisdictions. The president must assent to the bill. After the presidential assent, the bill is then what we call gazetted or published in the official publication of government, where they communicate to Ugandans that this bill is now an act of parliament and it has been released as an act. And that is called gazetting. So briefly, these are the different stages through which a bill goes through to become a law. And when it is now a law in Uganda, it becomes what we call an act. So it is now an act of parliament. And like we said, acts of parliament are sources of law because they are laws or legislation that is done by parliament. So the second type of legislation that we have is what we call the statutory instruments, or the subsidiary laws to the acts of parliament. You'll find that every act of parliament has subsidiary rules or regulations, and those are called statutory instruments or SIs. So these SIs are done by other bodies that are not parliament, bodies to whom power has been delegated to make law. For example, a department of government or a ministry, the minister makes the laws. And these are subsidiary laws, or they are laws that fall under the parent laws. For example, if you have a main law on noise in Uganda, you could find that there's need to do the rules that govern noise, but they are not the main law. The main law exists but doesn't have the rules of implementation. So those rules will be made by the minister, who will break down the nitty-gritty of what actually is going to be done concerning the rules on noise. Those will be the statutory instruments on noise. There will be the rules on noise. And they are a source of law because they come from the minister or a body that has been delegated power to make law. So the third legislation that we have is ordinances, and these are also subsidiary laws, and they're made by district councils. For example, you find that Wakiso Revenue Ordinance, and these are done by the lower bodies really that have power to make laws. And usually an ordinance is first sent to the Attorney General when it's been made to ensure that it's consistent with the Constitution and all other existing laws. So ordinances are another source of law, and they are a type of legislation that provide law in Uganda. We also have the bylaws as another type of legislation in Uganda, and these bylaws are now made by the lower bodies, now more lower than the ordinances, like the local authorities. You find village laws, laws under the Local Government Act. All those laws are made by the lower bodies or local authorities, KCCA laws. Those are mainly binding on people within the scope of their jurisdiction, and they are law and recognized as law in Uganda, and they are another type of legislation, and they are another source of law in Uganda. So under the sources of law, we talked about the Constitution as the first source of law. Then we talked about legislation. Now the third source of law in Uganda is common law. And by common law, we are talking about the laws that came from medieval Europe and were brought down into Uganda, that we adopted by virtue of the fact that we were British colonies. So at the time in Europe, there were laws and policies and customs that were existing and were deemed law and were good law. So Uganda adopted them and took them on. And today they form a lot of what we see in the Contract Act, in the tort, and these are principles of law, Partnership Act as well, Sale of Goods law. Most of them came from Europe, medieval Europe at the time. And they became law, or they are a source of law for Uganda. As you can see, they've been made into acts right now, but they are a source of law in Uganda because we adopted them and they've still been in existence, modified to date, but still prevalent. So common law is a source of law in Uganda. Common law is usually attached with equity. They call it common law and equity. So equity is another source of law, and by equity we are looking at the principles of natural justice and fairness. You'll find that many of the principles of the common law that were adopted were so strict in nature that sometimes justice was not even served because we were following the strictness of the law. For example, they would say if you submitted your application badly in court, to be dismissed. Before they even hear their merits, it will be dismissed on, you know, what they call POs. So equity came in to soften the law, to try to find remedies where there are no remedies, to create natural justice, fairness, you know, to bring natural justice to people. So equity is a softer side of the law. The laws or the principles, and it's mainly form of principles actually. For example, you know, if you seek equity, if you seek fairness, you must give fairness, you must be fair. Or if you come to plead that you should be treated fairly, you should have acted quickly. Equity, delay defeats equity. So you find equity is a source of law because, you know, these principles of natural justice are actually applied today in courts of law. Another source of law is what we call case law, and case law is what also is known as judicial precedent, whereby cases that have been decided elsewhere by superior courts are binding on the lower courts. For example, if a matter has been heard before by the Supreme Court and facts that are similar to that case appear again before a lower court, maybe the High Court or a magistrate court, the High Court and the magistrate court are bound to follow the decision that was made by the Supreme Court. So precedent means what was decided in the cases before is applied in the case at hand to address the case at hand. So it's a source of law because the cases that were decided before time are binding or are providing guidance to the judges in the cases that the judges are dealing with now. So you find that the doctrine of precedent is very, you know, is very known in law because it establishes what is, it deals with what was held before or what was decided by court before, where facts are similar to facts at hand. So the last source of law in this video is customary law, and customary law is a source of law in Uganda, especially for those customs that one have been in existence since time immemorial. Elders can vouch for it and say that these customs are in existence. They are not contrary to natural justice or unfairness. They treat people well, and then also they are consistent with existing law. They don't contradict either existing laws or the constitution. And also one thing you should notice is that customary law is mainly applicable only to civil matters. In other words, it's not relevant for criminal matters in Uganda. So it's a custom. You find, for example, Kwanjula sessions are now law. You know, Kuhinjira, those are examples of customs that have become law in Uganda. So customary law is a source of law because they are laws that have been created as a result of customs that have been in existence since time immemorial, and the customs are in line with natural justice and they don't contradict any other existing laws in Uganda. So in conclusion, this video was really talking about the sources of law in Uganda. Where can one find laws in Uganda? If one is looking for laws, where would they find them? Or where do Uganda's laws come from? As we said in this video, they come from 6 main sources. They come from the constitution, legislation, case law, customary law, common law, and the principles of equity. Now, if you want me to record any other tutorials to help you understand a topic better, do not hesitate to rate it in the comments. I read all the comments and I take note of them, and I'll make another video for you on the topic that you want to know about. Thank you for watching. Have a good day.